Welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast, and a big hello to everyone in between. I'm Dan Balkaran, as you see on the screen, and I'm going to be your employment lawyer for the next 30 minutes or so. I am an employment lawyer at Samfiru, Tumarkin, LLP, as always, Canada's leading employee side employment law firm. Just some housekeeping notes before we get started. If you want to reach us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, please send your questions in. I will try to get to all of them through the course of this 30 minutes or so. Got a couple rolling in now, but please send them in when you have them. Okay, question from Dan. Dan, you have an excellent name. I received working notice and need help understanding how this affects my severance. Can you explain? Yeah, that's a great question. So your entitlement at law when you've been terminated is to the working notice. It's a heads up. So, hey, Dan, the bad news is we're going to terminate your employment in 3 months. But the good news is we're going to continue to provide you with your paycheck, and we'll give you time off to look for another job, and hopefully you find one so you're not unemployed for very long, if at all. It's really just the public policy notion that employers bear some responsibility for offsetting the financial catastrophe of unemployment on their employees just by sort of providing you a little bit more time to find a new job. That's it. That's all you're entitled to at law. However, 95% in my experience of employers choose to terminate an employee today. Okay, and the reason why is for the most part, it's because an employee who knows they're going to be terminated in 3 months or whatever is certainly potentially a sabotage risk and a morale risk to employees who have not been terminated, and is just sort of generally uncomfortable. And so what employers will almost always do, although not always, is they will choose to terminate that employee today. But if you're terminated today, you're still entitled to that heads up, that working notice period. Let's just say it's 3 months. But since you don't get it because they're terminating you today, that period of notice converts into money that you would have received had you worked it. And that money, without working it, is called severance. So severance and notice are interchangeable as far as the math is concerned. However, your legal right is only to the notice. So if they've only provided you with working notice, that's certainly within their entitlement, provided it's the right amount of working notice. Now, if it's the wrong amount of working notice, you still might have a severance claim at the end, but you don't want to actually make that claim until the working notice period has expired. Because if you do, let's just say you have best day of 20 months of working notice coming to you, and they gave you 3, you don't want to tell the employer right away, hey, you gave me the wrong amount of notice, I want severance, because then what they'll do is potentially what they could do is rescind the notice, the termination, and then issue you new working notice of, say, 20 months. And then you've got to work there for 20 months, and then you're done at the end. So quite often when a working notice is provided, it's usually because there's either a reason for it, like shutting down an office, or they need the employee to work a certain period of time, or it's a negotiating tactic to provide less money in a lump sum or salary continuance to the employee. Because if you give most employees the option of, say, we'll give you, 10 months of working notice, or we'll pay you 5 months right now and you don't need to work at all, employee will usually take the 5 or 6 so that they don't have to work and then move on. So yes, they can do that. Whether or not you have a good claim at the end of it, Dan, or some sort of negotiating position, I can't tell you that from your one paragraph question. And I recommend that you do speak to an employment lawyer to find out. And if you need to speak to us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Okay. Jackson asks, I was let go because there were false accusations made about me at the workplace. There was no workplace investigation done, and the new manager at the company had previously made it known that he wanted me off the team. What can I do? Well, Jackson, the question is, did they terminate you for just cause and pay you zero? Or did they terminate you without cause and provide you a certain amount of severance or notice and severance that may be the correct amount at law? So that last piece is a wrongful dismissal if they did not. And all wrongful dismissal means is they fired you and didn't provide you with the correct amount of severance or notice, or some combination of the two. And so when you say let go with false accusations, it makes me think that they terminated you for just cause. Now, just cause is where an employer terminates you and provides you no notice, no severance. So if you could, if you're listening to this, if you could just let us know if you were terminated for just cause and therefore provided no severance, or if they terminated you and provided you with some amount of severance, but you want to assess whether or not that was the right amount, because that's the question. And so underlying your question, if you were terminated without cause, is this question, well, can the employer terminate you, or what is your legal right in the event of your termination? And the answer is, if you've been terminated without cause, it's severance. It's what's notice or severance. So in effect, it's money. Okay, that's it. You don't have, unless you're federally regulated and you meet certain criteria, and most of us aren't in federally regulated, then you're not entitled to reinstatement. Can't get you your job back. No employer can. No employment lawyer can. And your only recourse is a claim for money, effectively. So the question becomes, did they provide you any money? And if they provided you money, was it the right amount of money? So if they provided you 10 cents on the dollar, you may have a good claim for the rest of it, depending upon the nature of the accusations and whether or not what the evidence is against you with respect to those allegations. So if Jackson, if you could let us know a little bit more, I'll give you further answer to your question. I don't want to identify this person, so I'm just going to call this person L. L asks, can my employer let me go for something I shared privately on social media? Oh, that's a really good question. I didn't share anything specific about names of people or the business, but have been threatened with termination because they found out and I'm unsure of my rights. Well, I mean, this is a tough one for me to answer here because I need more information, and I don't want you to give that information in this public setting, doubling down on the allegation that they made, about it looks like some sort of breach of confidentiality or something. Listen, I don't know what it is that you said, but if it's a breach of confidentiality, it doesn't matter that it was a privately shared conversation on social media or publicly broadcasted on social media or said to a friend. If you are in possession of confidential information, like say, the particulars of a deal with a client that you're not permitted to share, you can't tell your buddy about it, right? And if you did that, is that an offense that rises to the level of just cause such that they can terminate you and pay you zero? Because remember, that's what we're talking about here. They can terminate you at any time, but the question is, are you entitled to money, effectively? So are you entitled to money for this termination? And again, same question to you, Al, did they fire you and pay you zero? Or did they give you a certain amount of money, but you want to know if you were entitled to more money? Your underlying question, if you revealed confidential information about the company to someone you were not, or something to do with your employer to someone you're not supposed to share that information with, and they got wind of it somehow, then it doesn't matter. You're still in breach of confidentiality. If it's, however, if it's sort of general, if, however, you said something on social media, so this is in the news, that's why I said it was a good question initially, and it is a good question, but I had thought you were talking about saying something on social media that the employer fires you over because it brings the employer's reputation into disrepute in some way. Now, that's a higher bar, and if that's what happened, can you be terminated for sharing something on social media that the company deems to be offensive or a problem, or brings the reputation into disrepute? They can. It has to go to it has to really go to the heart of the relationship, and be something that affects the reputation of the employer, we'll say. Now, can that happen if it was shared privately? That's the interesting question, and I don't know the answer to that question. I would have to say no, because it's a private message. But if it's a private message and then it gets out, is there a reasonable expectation that that you have to expect that a private message might become public? Well, it depends who you are. If you're and depends who the other person is. If it's your best friend, no. But if it's someone you don't really know, then maybe. So I don't think that's what you're asking, though. I think you're talking about a breach of confidentiality. I don't recommend that you come back into this chat and say anything more about the specifics of what you did. I think you should talk to an employment lawyer immediately. You can let us know if you were terminated for cause or not, and I can talk a little bit about that if we have time. But you see on the screen employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Al, I think you need to talk to an employment lawyer right away. That's too complicated, and if you shared confidential information, to somebody on social media, does it rise to the level of going to the heart of the relationship such that the employer can no longer continue with you? That brings in questions of proportionality that need to be assessed on a case-by-case basis, and that is information you can't double down on what the allegation is by sharing it in this public setting. So I will direct you to talk to an employment lawyer and with your specific issue, but I do think you should talk to one right away. I'm not going to reveal this person's name either. Call him B. How do you deal with a performance improvement plan if you don't agree with it? Oh, these are great questions. Okay. So for those who don't know, a performance improvement plan is given to an employee as very close to a last resort. It's the employer saying, we're not happy with your performance. You need to fix X, Y, and Z in order to continue with the company. And if you don't fix X, Y, and Z, we're going to take further action, including up to termination. Now, in my experience, performance improvement plan is very hard to come back from. I look at them more as, and certainly employer counsel would disagree with me, but I look at them less as a tool to elicit the change that the employer wants to see in the employee, and more as the employer papering its steps to terminate the employee with no cost or a lowered cost to the employer. And what I mean by that is, we've talked a lot about just cause so far in this chat, and what just cause. So I'll back up the first principles here. So if your employer terminates your employment, as I discussed at the beginning, you're entitled to notice, or most of the time, depending on how the employer terminates you, severance. Okay, and severance is money. Okay, so you're entitled to money, and the presumption is that you get money. But in certain situations, if the employee acted in a way that damages the employment relationship beyond repair, the employer can be justified at law in paying the employer or the employee zero, and that's called a just cause termination. Most of you probably have heard of that. And there's really two broad ways to get there. One is a single incident that is so egregious that the employer is justified in the just cause termination. So that would be, theft, punching your boss in the face, sexual assault, sexual harassment, committing an indictable offense, very serious misconduct. And it has to be serious misconduct because the bar for just cause is, remember, you get by default, you get the severance. So the law wants you to get severance, but in certain situations, the employer doesn't have to. But the bar that the employer has to surmount is very high, but it certainly can happen. So one way to get there is the single incident, and the other is progressive discipline. Progressive discipline, the 3 written warnings and you're out. And about the same issue, right? About the same material problem that the employer is allegedly having. Performance improvement plan, to me, is just ticking a box on the progressive discipline process, the progressive discipline highway. The employer is laying the groundwork to be able to say, yeah, we tried everything with this individual and we couldn't get them to fix their performance, so they've got to go, and we're going to terminate them for just cause because we gave them all the warnings and they didn't fix it. Or we have just cause to terminate you, but we're going to provide you with 20 cents on the dollar, take it or leave it. And it can be a very powerful negotiating tool. So that's the way I look at performance improvement plans. But that wasn't your question. So just generally, I think that they're hard to come back from. I've certainly seen it, but they are hard to come back from. So that wasn't your question, though. That was just background. What do you do if you don't agree with it? I think if you fight your performance improvement plan, you're not going to be an employee there very long. And listen, I think the odds are stacked against you if you've been provided a performance improvement plan. You may want, I don't know what your situation is, how long you've been there for, but if you were talking to me as my client, probably one of the items I would suggest to you is, do what they're asking you to do while you are using that time as a working notice period and look around for a different job, because it's very hard for the relationship, especially if you don't agree with it, for the relationship to continue. But if you say to them, if you fight the employer on the performance improvement plan, you're just going to ultimately end up losing your job. That's really what that is. So what I generally tell people who've been callers and clients who've been issued a performance improvement plan is, whatever they've told you to do, do it. Say, listen, all right, well, you've told me I need to do A, B, and C to remedy my performance defects. Happy to do it. I want to remain here as an employee and succeed here. So I'm going to tackle these items and check in with you for feedback, and you let me know how I'm doing. That's really the only thing you can do. And it's still I'm not going to say it's a losing proposition, but the odds, I think, are stacked against you. It's much more likely that your employment does not end up continuing. Obviously, there's lots of variation. It could be an employer who doesn't fire people. That happens, and they're just trying to correct some performance issues. I don't know the material circumstances of your matter, and you may wish to talk to an employment lawyer. Again, you can reach us at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. But generally speaking, the odds are sort of against you that your employment's going to continue there. And if it were, I won't say you specifically because I don't know your information. I'll just say generally, what I tell callers or as one option in that situation is, toe the line, look around for a different job at the same time, move on if that makes sense financially. It could be that the job you're in you need to keep because it's paying you way more than the market will, but it's a tough thing when you have a performance improvement plan. But I'm not giving you specific advice. I don't have enough information, and I'll say to you, you need to talk to an employment lawyer so you can get that specific information. Peter asks, I was recently diagnosed with a terminal illness. Very sorry to hear that, Peter. It's not clear yet how quickly things will progress, but I would like to continue working for as long as I can to support my family. Do I have to talk to my employer about this? I don't know the nature of your illness. I don't know if it's it's something that will become very visible very quickly. I think at some point you're going to want to do that. If those are your wishes and you want to work to support your family, I would be very surprised if the employer did not support you in your wish. But I mean, technically, no, you don't. You don't have a human rights obligation to report your illness to your employer. Although if your ability to perform your job is impaired by your illness, to forestall some sort of disciplinary action, you're probably going to have to advise them. And so I would, again, I think this is something you want to talk to an employment lawyer about with more details. It's very hard for me to give you any sort of specific impression based on your short question. But I imagine through this process, I don't know how long your situation is, but you're going to want to talk to them at some point. And if they take some sort of action against you, you do have a human rights complaint, and they have the world's worst press. So I would be surprised if they weren't supportive, but I understand why you asked the question. I would recommend talking to an employment lawyer before you make your decision about telling them. But I expect somewhere through this, you're going to have to tell them, is my expectation. But that's not any sort of specific advice. Again, if you want to talk to an employment lawyer, employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Peter, I wish you sincerely, you and your family, all the best with this difficult situation. Yeah, I'll just leave it at that. I wish you all the best. Jackson's back. Is an employer allowed to confiscate employees' phones during working hours? I don't know. I've never encountered that. I have no idea. I've never seen law on that point. If you're using your phone for personal use during company time, you're committing effectively time theft, and you could be in trouble from a performance perspective. You'll be in trouble from a discipline and eventually cause termination perspective. Can they just straight up confiscate your phone? No is my short answer. But you've got a different question here, or a different problem here, Jackson. If they're taking your phone from you at the start of your shift, there's so little trust between the parties that between you and the employer. I just don't see how your employment continues. How can you work at a place that's confiscating your phone? And so, you may want to see if that is the right fit for you, that particular employer. And maybe it is. Maybe it's the only game in town. Maybe you're in a small town and that job is paying you 100% above market rates. It happens in small towns. Sometimes there's one employer and that employer is king in that small town, and you got to keep your job. And so that particular employer isn't very nice to its employees sometimes. But that's a hard thing when they're confiscating your phone, if that's what they're doing. And if it were me in your shoes, I would take a long look at whether or not that was the employer I wanted to work for. Question from Jed. I was let go after 2 years with my company due to work shortage. They paid you out 2 weeks. Well, they said, you said that they didn't offer you any severance, but they paid you 2 weeks. The 2 weeks is the severance. Am I still able to try for more? Would accepting that payment stop me? So most likely you're provincially regulated, which means that 2 weeks pay was the 2 weeks that you were owed under the Employment Standards Act. Whether or not you're entitled to more money depends on what your employment contract says. You get a presumption of reasonable notice. We'll call it. There's two types of severance if you're provincially regulated. Small severance, which is statutory, comes from the Employment Standards Act, roughly 1 week per year of service to a maximum of 8 weeks, roughly. Or big severance, which comes from the common law. It's decisions by judges over time about severance. It's much more generous. It's closer to 1 month per year of service. So that's where you want to be. For short service employees, particularly in BC, maybe not in other jurisdictions, but in BC, short service employees who have 2 years of service, you're sort of looking at under 3 years of service, you have a 2 to 3 month floor. If you're in a supervisory position and you're over 2 years, 2.5 years of service, it can be 4 to 5 month floor. There's law on that. So it can certainly be more money. Or if you've been unemployed for a long period of time, it certainly can be more money. So it may be, depending on what you were making, that could be something that you'd want to explore, but it depends what's in your employment contract. And to find that out, if you have a claim to more, you need to talk to an employment lawyer. I'll give you the details at the end. I know I've said them a number of times, but we're almost wrapping up here. So if you can just wait to the end, I'll give you our contact information to reach us if you want to speak to us. But the short answer to your question is, yeah, you could be entitled to more. Question from Naomi. I recently started a new job, and was called into a meeting with my manager. I found out that my old employer contacted my new manager and was bad-mouthing me. Is there anything I can do about this? Is this legal? Well, did your new employer contact your old employer as a reference, or of its own volition did your old employer contact your new employer and just start disparaging you unsolicited? If it's that second one, and it's not true, what they're saying, you could certainly initiate a lawsuit for defamation. Certainly, lawsuits can be in BC Supreme. Let me rephrase that because it's across the country. In Superior Court, have court costs attached to them if you are not successful. And defamation cases aren't the easiest cases to win, and it's not clear what the harm is, right? Like for defamation, where defamation cases struggle is, what is the actual harm to you? How is your reputation affected, and therefore, what's your loss? You could bring it in small claims, though. Generally speaking, in most jurisdictions, small claims have no court costs or risks, and you can do it yourself. You don't have to get a lawyer to go through small claims. And although it is challenging, but you may want to do it as a deterrence. It's a weird thing. Splitting the difference on that, you may want to hire a lawyer to write you a letter, and that lawyer can write a fairly aggressive letter telling your old employer to cease and desist or risk further legal action. That's probably the most affordable and easiest way to get them to stop. If that's what you want to do, have them stop. If you want to seek redress, then you'd have to bring a claim in court, most likely for defamation. Okay, it looks like it's the last question, which is good because we're out of time. Question from M. Can your employer decide to change the bonus structure from lump sum cash payments to stock units vested a year after being awarded? This change also effectively means I cannot leave the position until more than a year, as I would not be given the bonuses I have worked for and earned. Yeah, so employers will often, they'll say to you, hey, look at all this compensation we're going to give you, but that compensation has trigger riders on it where you can't get it for a certain period of time, or if you quit before a certain date, you don't get it. It's a way to, I'm not going to say trick the employee, but it operates to incentivize the employee to work for the employer, but it means for a lot of employees, when they quit to move on to something else, they don't get their full compensation. Is it legal? Sometimes it isn't, depending on the nature of what's being paid, how long it's been paid for, what your employment contract is, etc. So your bonus structure, if it's a lump sum that's paid at a certain portion of time, and now they're pushing it off for a deferred year, the question is that a constructive dismissal, right? Is this change so material? Is it a fundamental term of your employment that you get paid it now as opposed to deferred for a year, that effectively the employer is breaching your contract of employment such that you're no longer an employee? That's really the question. We don't have time to get into constructive dismissal doctrine in any serious degree. I'll just say, for that to be the case, your bonus would have to be, in BC at least, probably 20% or more of your total compensation. And even then, they're not saying they're not paying it to you. they're saying we're deferring it for a period of time. Could that be? Yeah, it could, but it would have to be at least 20% of your pay. And certainly I've spoken to people, employees whose pay, bonus or some sort of incentive compensation is half of their pay. But if it's, you're talking about, 4% of your total pay, no, it's not going to be a constructive dismissal. And why would you want a constructive dismissal? Because it triggers your termination and enables you to go after severance. You would only do that if you're entitled to a significant amount of severance. If you're only going to get 3 weeks of severance, there's no point in doing that. You might as well keep working there. And if you're totally dissatisfied while you're working, drawing a paycheck, you can look for a new job somewhere else. So the short answer to your question about the bonus structure change is it depends. My guess is, and this is based on nothing, I don't have any specific information from you. My guess is, there's nothing you can do about it, most likely. But it depends on the seriousness or how big the actual bonus amount was, and how fundamental to your compensation in terms of employment the change actually is. So if you want to find that out, you want to get an opinion on that, you should talk to an employment lawyer, because it could be, right? And if this is the last straw for you and you want to move on, maybe you can trigger a constructive dismissal and get money on the way out the door. So if you want to find that out, you can talk to an employment lawyer. You can talk to us if you want at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Okay, as always, great questions. I'm happy we got through all of them. Join us on Monday, June 3rd. Monday, June 3rd with Chris Justice. He's going to answer all your questions about employment law. You'll see me, I believe, in 2 weeks at the same time. And as always, have a wonderful and safe weekend.